There are some real concrete, specific questions today about executive action that force us to ask really what is the executive subject to law, which is the basic thrust of Article 39, right, that the authority is subject to law. You can take the example of drone strikes, for example. This is a due process question in the sense that something's being taken away from people, namely their lives, without a hearing, without any kind of judicial ruling, but simply as a result of internal deliberations within the executive branch. So the Obama administration has explained that to them, due process doesn't always mean judicial process. In other words, due process is a flexible concept. Any lawyer will tell you that, but that in fact it's so flexible that it can be stretched to say that you can deprive someone of their life without going to a court. The deliberations that suffice to be due process can take place completely outside of a court and without any judicial official being involved. And this is something I think we need to talk very seriously about, because what does due process mean if the executive can take life without a trial? I mean, that sort of directly contradicts what Article 39 says.
The barons certainly didn't think that's what they were doing with King John, did they? I
think they would have had a problem with that, yes. And then there's something that some legal theorists talk about, which is the state of the 20th century. Carl Schmitt basically said that there was always a space beyond law in which the executive had to operate at certain times. And so the executive was normally bound by the restrictions of the Constitution in a constitutional republic, but that sometimes that state of things had to be suspended, and we moved into this other space beyond rules, beyond constraint for the executive. Obviously, this is a fundamental problem of legal theory, because once you say the executive is not bound by law, not only are you going against this core principle of the Magna Carta, but you're also in a sort of, there are no limits, essentially. Some legal scholars have struggled with this idea, trying to come up with a model of what would an emergency constitution look like. Bruce Ackerman has said that we could have an emergency constitution that kicks in at a certain point, and it would suspend certain kinds of limits on executive power, and then for it to continue, it would have this is quite a mouthful, but a supermajoritarian escalator, which is, classic academic jargon, but it's not a thing in a shopping mall. It's actually a principle that says the longer the state of exception goes on, the larger the supermajority that has to approve it. So scholars have grappled with this idea, and particularly after September 11th, if there's going to be a state of exception, an emergency constitution, what triggers it, how long does it last, what rules apply? And it's one of these tantalizing problems, because once you admit that there are no limits, how do you put limits back in? So that's the sort of one of the conundra of executive authority in our time, looking back to this basic principle of authority is subject to law.
That's an excellent answer. I appreciate that. Jenny, talk about jury trial and how Magna Carta is obviously, from my opening comments, well, I think it's had a great influence in this country.
It actually belongs sort of in the category of the myths of Magna Carta, because the word jury does not appear anywhere in Magna Carta. So the idea that Clause 39 of Magna Carta guarantees the right to a trial by jury is actually a much later interpretation of Magna Carta. That's not what anybody thought in 1215. It's a really interesting example of how two phenomena can coincide in time and then over a period of time actually coalesce. So what you have is Magna Carta being agreed to in 1215, and that very year you have a huge event in the Catholic Church called the Fourth Lateran Council, where Pope Innocent III, who annulled Magna Carta